Hello and welcome to Skyline, ladies and gentlemen. I'm Driti Atri and we are back with another episode tonight. We are connecting the dots across America, Canada, India and the global Indian diaspora. Because immigration is no longer just about getting a visa stamp anymore. It is about your job. It is about your green card, your citizenship, your money, your investment, your ability to travel. And sometimes your entire family's future as well. And tonight, we have 13 important stories that bring all of these pieces together. And guess what? At the middle of all of this is a much bigger question. Is the global Indian professional still living in the era of opportunity, or are we entering an era where every visa, every document, every financial transaction, it comes under a much sharper microscope? Well, let's begin with America tonight. If you are currently working in the US on an H-1B or L-1 visa or managing a foreign tech talent, a major Department of Homeland Security regulatory rule, it is taking effect September 9, 2026, and it is about to drastically increase the cost of maintaining your legal status. The US Department of Homeland Security has published a final rule expanding the 9/11 response and biometric entry-exit fee. Well, for the very first time, covered employers will be forced to pay an additional $4,000 fee for H-1B and $4,500 for L-1 extension, even when the workers remain with the exact same company. Well, for the Indian tech professionals who are trapped in a multi-decade green card backlog, this policy shift, it carries severe financial and career consequences. Now, here's the complete breakdown of who pays, why the DHS changes the rule, and how it impacts you. Well, to understand how this rule actually works, we must look closely at the statutory criteria established by the DHS. Well, the $4,000 and $4,500 surcharge, it is not a brand new tax, but an extension of a fee created under Public Law 114/113. Previously, this fee applied almost exclusively to initial visa petition or when a worker changed employer. Under the new rule, effective from September 9th, DHS has revised its legal interpretation to mandate this payment on the same employer extension. However, the fee does not apply to every American business. It's a point to note. An employer qualifies as a covered employer subject to this surcharge only if it meets two strict conditions. First, the company must employ 50 or maybe more workers in the US. Second, more than 50% of the US workforce in the aggregate must hold the H-1B, L-1A or L-1B non-immigrant status. So this means mid to large IT consulting firms, global capability centers and tech service providers will bear the overwhelming burden of these costs here. Now, you know why this specific rule hit the Indian non-immigrant specifically here? Well, ladies and gentlemen, the core issue lies in the employment-based green card backlog. Due to the per-country cap on the EB2 and EB3 immigrant visas, Indian nationals frequently wait for about 10 to 20 years or maybe longer for a permanent residency in US. Now, because H-1B status is initially granted in 3-year increments up to 6-year limit, workers awaiting an approved I-140 petition, they must continuously request 3-year H-1B extension under the new regulation. Well, during the public comment period, Indian visa holders and industry representatives, they voiced sharp concern here, noting that Indian workers undergo repeated renewals simply to remain legally employed while waiting in the line for a green card. Well, the US, they formally rejected these obligations here, stating that the Congress established the fee framework and that green card processing backlog, it falls outside the scope of this rule. In the meantime, DHS projects the expanded fee, it will generate nearly about $157 million in revenue to fund the US Custom and Border Protection biometric system here. And that's a huge amount, by the way. But yes, the question is, can an employer require the employee to pay this $4,000 and $4,500 extension surcharge? Well, let me answer that. Under the federal regulation, the answer is a strict no. DHS explicitly clarified that federal law mandates this fee must be paid by the sponsoring employer. Therefore, the US Department of Labor rule, it strictly prohibits the employer from deducting this fee from the worker's salary or requiring worker to reimburse these costs as an additional continued employment. Now, because large tech consulting firms file thousands of H-1B extension every single year, this regulatory change that adds tens of millions of dollars in these corporate overheads. Industry analysts, they warn that higher renewal expenses, it could maybe influence the corporate staffing model, escalating the offshore headcount expansion in GCCs in India rather than sponsoring long-term US renewals here. So if your current H-1B or L-1 visa extension is approaching, here is your tactical compliance playbook. Ladies and gentlemen, as the US immigration filing costs rise, remaining fully informed on policy shift, it is essential for safeguarding your career in the United States. Now, let's hop on to another story tonight. If you're currently working in the US tech sector specifically, and here specifically again on H-1B visa or perm labor certification, a massive structural shift inside big tech, it is directly threatening the middle level and senior engineering job security in 2026. Layoff tracking data reveals that over 125,000 tech employees here, they have been displaced globally in 2026, already surpassing total tech jobs losing from all of 2025. Now, unlike the previous layoff cycle driven by the over-hiring or maybe economic slowdown, this wave, it is explicitly driven by corporate AI reconstructing. Companies reporting record revenue, they are quietly dismantling the traditional software engineering team just to fund what? AI. And here's the deep breakdown of what is happening inside Silicon Valley, how these silent layoffs, well, they are trapping the visa holders and your exact career survival playbook. And yes, to understand the scale of this reconstructing, we must look at data compiled by tracking platforms. Platforms like layoffs.fyi and challengers. So let's start with it. More than 54% of all tech layoff events in 2026 specifically cite AI adoption, automated workflow integration, or organizational reconstructing towards AI-first business models. In fact, major tech giants, you name it, Meta, Microsoft, Amazon, Dell. Now, all of these major tech giants, you name it, Meta, Microsoft, Amazon, Dell, they have all executed significant headcount reduction while simultaneously increasing capital expenditure on AI data center, custom silicon, and, in fact, machine learning model. In the meantime, Oracle, they have laid off 20,000 to 30,000 roles, including sales, Microsoft division, just to expand AI cloud infrastructure. In the meantime, Microsoft and Meta, they have also trimmed thousands of roles. Well, recruiting or sales, anything, just for what? AI-focused teams. Enterprise software, over 88% of the enterprise software cuts have been concentrated in the US corporate operations, disproportionately impacting the H-1B and OPT professionals. But wait, why is the 2026 layoff wave particularly dangerous for the foreign workers? Let's talk about that. Well, instead of grand press releases and the broad severance announcement here, major tech firms are increasingly using the silent layoff. That's right. Through aggressive performance-linked exit, we call it PIP tightening, strict return to office, that is RTO mandates, and stealth team elimination. Companies are reducing headcounts, and that too without triggering the WARN Act public notices. In the meantime, for the H-1B visa holders, a silent PIP termination, it triggers the exact same strict 60-day regulatory grace period as a public mass layoff. Well, during these 60 days, you either find a new employer for yourself who is ready to file the petition for you, or change to another immigrant status. Maybe it can be anything, B1, B2 or F1 visa. Well, Depart the US, that is also an option. Compounding the crisis, major firms including Meta, Google, Amazon, they have extended freezes on perm labor certification processing, leaving thousands of foreign engineers here stuck in green card limbo while facing the job risk here. And while traditional full stack, QA and junior front-end developer roles, they are coming under severe cost pressure. Where is tech capital and where is hiring actually shifting? Well, market placement shows that while these developer hiring, they have been reduced, enterprise demand is surging in specific high complexity technical domain. Tough, let me simplify that. AI infrastructure and platform engineering, you name it, cloud reliability, MLOps, model development and high performance GPU cluster management, cybersecurity, data governance, all these AI related jobs, data privacy or anything that is related to artificial intelligence, these big techs, they are ready to invest more into AI driven jobs. And who is benefiting from that? India's GCC hubs in Bengaluru, Hyderabad, Pune, just to lower the operating cost while scaling the AI workflow. So these jobs are shifting from the United States to India now. So, ladies and gentlemen, if you are an engineer or corporate professional who's working in the US tech ecosystem, here is your tactical action plan. First, build a 60-day H-1B emergency plan for yourself. Keep your resume updated. Maintain a contact with maybe some recruiters who are working in big tech. Verify your immigration records, forms such as LCA copies or I-94. With that, audit your role's AI vulnerability. Transition your daily scope away from your routine. In fact, easily automated coding or maintenance tasks towards core architect, cloud computing or any AI-related job. With that, monitor your internal performance. Watch for sudden changes in managers' feedback or any unexpected stack ranking. Well, leverage your B1 and B2 status extension. If you're facing a layoff without an immediate job offer, consult an immigration attorney regarding filing a timely Form I-539, change of status, B2 visitor, or extend your lawful stay beyond 60 days. Big tech is undergoing its biggest structural reset in decades now, positioning yourself at that intersection of a crucial infrastructure and technical compliance. That is your strongest defense. As a fresh update, your money is crossing borders with you. That's right, if you are an NRI sending money between India and the US, or maybe your family in India is investing overseas, pay close attention because Indian wealth is becoming increasingly global. Ladies and gentlemen, under the RBI's liberalized remittance scheme, a resident Indian can remit up to $250,000 in a financial year for permitted purposes. And yes, that money can go into overseas investment, education, property, or other allowed transactions as well. Here the important point is that this limit, it applies to an individual, not an entire family. So when multiple family members are eligible, well, the overall amount that can move overseas, it becomes much larger if you see it individually. And this is where this story, it gets interesting here. Moving money is easy. Moving it compliantly is the real challenge. Families are increasingly using global investment not just to make money here, but to diversify the risk. A parent in India can invest abroad. Well, a child working in America can invest back in India. One side earns in dollars, the other side earns in rupees. Suddenly, the family is managing two currency. The family is managing the two tax systems and multiple reporting requirements as well. And then comes TCS, basically tax collection at source. It can apply to certain outward remittances, including the specified investment and the other transaction as well. But you know what? It may not be the final tax cost because it can generally be adjusted against your tax liability here. But it can still lock up a significant amount of cash temporarily for you. And for your family, moving a large amount of money that temporarily locks up, it matters a lot. Why? You may eventually recover or adjust it. But in the meantime, that money, it is not available for another investment, another payment, or another emergency for you. And yes, there is another layer that many people overlook here. Well, the purpose of the transfer here matters. Sending money for education, it is not treated the same way as sending money for an overseas investment. Buying foreign asset, it is very different from supporting a close relative. So, ladies and gentlemen, a simple mistake in declaring the purpose, it can create a lot of questions later on. For Indians in the US and their families, there is also the reporting side which we need to discuss. Overseas investment, foreign income, dividend, bank accounts, they may create disclosure obligations under the Indian or US tax rule depending on where you are the tax resident of. And you know what? That is why the cross-border wealth management has become much more than maybe choosing the right stock here. So yes, before you transfer that money, ask just 3 questions which are very, very important by the way. What is the purpose here? What paperwork is required? And most importantly, have I reported it correctly or not? Because let's be honest, today, global wealth is not just about where your money invested. It is about whether every single dollar and every single rupee has a clear paper trail or not. And you know, that same paper trail, it is becoming very, very important in another area too. Well, citizenship itself. Well, for many immigrants, becoming a United States citizen, it feels like the finish line. But what if the government starts looking backwards? That's right, ladies and gentlemen, sadly reporting what civil denaturalization allows the government in certain circumstances just to challenge citizenship that says was illegally obtained or maybe secured through material misrepresentation. And it's a big worry for Indians who are very dishonest when it comes to citizenship here. Well, this is where the old paperwork, it suddenly becomes very, very important for you. A visa application from maybe 15 or maybe 20 years ago, an old employment record, a previous identity, a marriage-based petition, or maybe a criminal history disclosure, a statement made during a green card application, everything matters now. All of it can become part of just one larger immigration history for you. And if it is incorrect, then it is a problem for you. Wait, the central question, it's very, very simple. Did your story remain consistent from the first application to the citizenship interview or not? You may ask why here? Well, because immigration records are increasingly digital. Agencies, they can compare information across different stages of a person's immigration history. Well, an information that looked insignificant years ago may appear pretty much important when it is compared with a later application here. Now, this does not mean that every naturalized citizen is suddenly under threat. No, I'm not saying that. Civil denaturalization is a serious and limited legal process. But it does mean one thing very, very clearly. Never assume an old immigration file. It is irrelevant just because it is old. Well, think about an applicant who gave one version of their employment history years ago and a different version during naturalization. Or maybe somebody who failed to disclose a significant fact because they believed it was too old to matter. Well, those historical details, it can become important if the government alleges that the information was material to immigration benefit. And you know what? That is why people preparing for naturalization need to know what is actually sitting inside their old files. What did you write on your first visa application? It's very important. What did you tell the USCIS years later? And what did you disclose when you applied for a green card? And yes, most importantly, what you are saying today. Well, those answers, it should tell one consistent story. There should be a whole chain. Well, if you discover something concerning, don't guess, hide it, or casually try to rewrite your history. Get proper legal advice, because when the government looks at your immigration history, it is not just looking at one form here. It is looking at your entire story. It is looking at your entire future. And you know what? Sometimes the problem is not the citizenship itself. Sometimes the problem is simply getting the permission to work. If you have the job, if you have the qualification, if your company wants you, but there is only one problem. Your work authorization, it has not arrived. Well, for STEM graduates, OPT workers and some employment-based green card applicants and EAD, it is not just another document. It is the document that allows them to work. That's right. And you know what? When processing slows down, the consequences, it can move very, very quickly. Beyond your imagination maybe. Your employer may have to review your form I-9. Well, your salary could be affected. Your benefits could be affected. Even practical things, maybe like your driver's license renewal, it can become complicated in some states. Now, think about a STEM PhD who's working in AI, biotechnology, or maybe semiconductor research. The person may be leading an important project in the US. The company may be relying on their expertise. But if their work authorization it expires and no applicable extension or another protection it covers them, the employer, well, that person may have a compliance problem later on. Your career, it is moving at Silicon Valley speed. Your paperwork, that is moving at a government speed. And that mismatch, it is where the danger lies the most. Well, some EAD category can classify for automatic extension when a renewal it is timely filed and the requirements are met. Other categories have a very, very different rule, by the way, and that is why one person's experience with USCIS it cannot automatically be applied to another person's case here. For somebody approaching an expiration date, that means timing becomes crucial. Check your renewal window, check your category, check whether you qualify for an automatic extension or not. Keep your employer and your immigration consul informed about it. Keep your receipt notices and immigration documents organized as much as possible. And yes, don't assume a processing delay is somebody else's problem. It is your problem. Because if you are the person whose card is expiring, the clock for you specifically is very, very real. Well, in immigration, a small delay on paper, it can become a very big problem in real life. And sometimes the problem is even smaller than that. Well, the problem, it can be just one wrong form. This may sound like the most boring immigration story tonight, a form addition date, but it can have very real consequences. That's right, USCIS updates its forms regularly. And when an old edition expires, submitting that outdated version, it can result in rejection. And you know, when an application is rejected, the problem is not simply that you have to print a new page. No, you may lose valuable time, miss an important filing window, or find yourself dangerously close to an I-94 or a work authorization expiration date. You think about it. Your documents are ready, your fees, it is ready, your lawyer is ready, your immigration is complete, and then USCIS says that, sorry, wrong form. Now, everything, it comes back. And you know, that is why applicants need to check the edition date printed on the form before submitting it, specifically around a transition deadline here. Don't rely on an old PDF that is sitting in your email. Don't use a form downloaded months ago. Don't assume that the form is still valid because it looks exactly the same. And be specifically careful when deadlines are close. A package mailed just before a change in form edition, it may still face a problem depending on when it is actually received and which edition USCIS it requires at that point of time. You know, that teeny date at the bottom of the page, it can suddenly become one of the most important detail in your entire application. And yes, there is another layer here. Many applicants, they are not filing alone. An attorney, employer, immigration department, or consultant may be handling the paperwork here. But the final responsibility, it still matters. Just ask one simple question here. Which edition are you submitting? Well, I do agree it is a very basic question. But sometimes the most basic question protect the most important things in life. Because immigration cases, they are often not destroyed by some dramatic legal mistake. Sometimes they are maybe delayed by something as small as a date that was printed at the bottom of the page. And if old paperwork can create problem for an application, can you imagine what it can mean when governments start looking backwards at immigration record? Well, let's hop on to our seventh story tonight, ladies and gentlemen. America is looking back. Let's hop on to our seventh story tonight, ladies and gentlemen. America is looking back. The biggest story here is not just denaturalization, it is retrospective scrutiny. Federal authorities can, in certain circumstances, revisit the older immigration records when they believe that citizenship was obtained unlawfully or through material representation, as I told you in the previous story. So you know what? That basically means that immigration history of a person can remain relevant long after the original visa was issued. Can you think about the journey of a typical immigrant here? First comes the student visa, then perhaps OPT, then an H-1B, and then employment petition, and then green card before the final citizenship. That means years of forms, years of addresses, years of employment records, and years of travel history for you. Ladies and gentlemen, every stage adds another record to the file here. And yes, every new application creates another opportunity for information to be compared with what you said before. A tax issue, a hidden identity, a past arrest, a disputed marriage, and inaccurate employment history. A document that was presented years ago basically. Well, these issues can become important when authorities are examining whether a benefit was obtained through material representation or not. Again, not every single mistake is a fraud, and not every old inconsistency, it means citizenship is at risk. Wait, that distinction, it is extremely important for you, but there is a powerful lesson here. Your immigration history, it follows you everywhere. And that is why people preparing for naturalization should know what is actually sitting inside their old files. What do you write on your first visa application? What did you tell the USCIS years later, and what did you disclose when you apply for a green card? And most importantly, as we repeat it, what are you saying today? Those answers, they should tell you one consistent story. Don't think the US government is a fool. Don't assume that your fraud, it is never going to be caught. Well, get the facts done, review the record, get qualified legal advice from the legal person, because the age of document, it does not necessarily make it invisible for you. And yes, while America is today examining immigration histories, another question is becoming increasingly urgent. Who is being removed from the country altogether? You know, for an Indian family, deportation is not just a headline. It can mean years of savings lost, dreams interrupted, and future suddenly rewritten. Indian nationals are among those who are being removed from the United States in cases involving unauthorized entry, overstays, and other immigration violation. And yes, behind every removal number, it is a person who may have spent months or maybe years trying to build a future in America. Ladies and gentlemen, one of the biggest dangers is the promise of an easy route. Agents, they tell the family that don't worry, we know the route. You will get across, you will find a job there. But illegal migration networks, they don't control the US border, do they? In fact, the US government does, which is very, very strict. And you know, when enforcement becomes stricter, the people who may be paid tens of thousands of dollars and also unknowingly, they can end up with nothing. No job, no legal status, and sometimes a removal order. And that is why the so-called shortcut, it can actually become the longest and most expensive route of all. Families can sell properties. Families can take loans, borrow the money from their relative, and huge amount on travel arrangement further. And after all of that, the person can still be detained or removed from the US, which is actually correct way to do that. You know, the story becomes even more painful when families believe that they are buying certainty. Well, they are not. There are no agents who can guarantee the outcome of a US border decision here. There is no secret route that can make immigration law disappear. And once a person enters the entire system through an unlawful route, getting back onto a legal path, that can become much harder or maybe impossible in near future. And yes, there is an important distinction between somebody who has entered unlawfully and somebody who is legally present but has an immigration problem here. Legal non-immigrants, they still need to take their status very seriously. Keep your I-94 current, keep your visa and immigration documents organized, understand your status, and if there is a problem, don't wait until the last moment. Because let's be honest here, once immigration enforcement reaches you, well, panic is not a strategy, preparation is. And yes, while all of this is happening at the border, India is making moves much farther away from the United States. Let's hop on to the global energy market tonight. Ladies and gentlemen, let's move from immigration to energy because oil is power. India has spent years trying to diversify its energy sources. And now Venezuela is part of that larger strategy. ONGC Videsh has invested in Venezuelan oil assets, but sanctions and financial restriction made those projects extremely difficult to operate or even monetize. The challenge that is not simply getting oil out of the ground. It was also about banks, shipping, insurance, maybe payments, and sanction compliance. You can own an asset and still struggle to use it effectively if international companies are worried about violating sanctions. A field can be producing oil, but if the money cannot move freely through international financial channel, then the commercial value of that particular asset, that becomes much harder to realize it. And that is why any significant change in the sanction environment, it becomes important. According to reports, OFAC authorization involving ONGC Videsh, that could give the company more freedom to operate, invest, and potentially recover funds associated with its Venezuelan asset. If we see it from an Indian POV, then the importance goes far beyond one company. More Venezuelan crude, it can mean another source of supply. For ONGC, greater operational control, it could mean more production and better return. Now, if we see it from Washington's point of view, allowing carefully controlled oil activity, it can serve a broader geopolitical purpose. Well, there is also a financial angle here. If previously trapped revenue, it can be recovered. Well, that is not just a bookkeeping exercise. It can strengthen the company's balance sheet and it can give it some more room just to invest elsewhere. And this is where the global picture, it becomes interesting. India is trying to protect itself from over-dependence on any single energy supplier or any single region. Venezuela gives India another potential source of heavy crude, while the US can use sanctions and licensing decisions just as a policy tool. So this is not simply an oil story. It is a story about sanction. It is a story about energy security, and it is a story about India's growing role in global power politics. Because today's geopolitics is not fought only with armies. Sometimes it is fought with oil, bank, maybe shipping route and licenses. And sometimes, incredibly, it can start with something much smaller. Yes, one social media post. Can you imagine this? One unverified account posts a claim. Somebody translates it. Another account reposts it. Well, a television channel, it picks it up. A politician shares it, and suddenly a rumor, it starts looking like an intelligence report. Ladies and gentlemen, that is the danger of what now we call narrative laundering. According to reports, a viral fake quote, a quote about Iran that allegedly traveled from Indian social media account into Israeli and American political conversation. Well, important lesson is not just about one fake quote. It is about how quickly information, it now moves between platforms, countries, and institutions. The first person may know the claim, it is unverified. The second person assumes the first person checked it well. The third person sees 2 sources. The fourth one sees 10. And suddenly nobody remembers where it all starts. Well, the original account, it almost disappears. While the claim itself, it becomes louder and louder. And that is what makes this so dangerous in geopolitics. A fake military claim, it can move oil prices. It can create market panic. Well, it can influence public opinion, it can grow public pressure, it can grow government pressure. Investors may react before the journalists. They finally check the facts here. Officials may force to respond to a story that should never have existed in the first place. Now, ladies and gentlemen, let's talk about a quote here. A fake quote linked to a senior Iranian military commander quickly spread across social media and reached high level of the US and Israeli governments within hours. The quote, it was attributed to the Brigadier General Ahmad Wadehi, basically a senior commander in Iran's IRGC. It falsely claimed that Wadehi had said that Iran would never give up its nuclear ambitions as long as the US and Israel had nuclear weapons. Well, according to the New York Times, there is no evidence that Wadehi ever made this statement and that Iran has developed nuclear weapons here. The post, it came from an anonymous Indian X account with about 175,000 followers, and the account, it had previously been flagged by fact checkers and Pakistan's government for spreading false and Islamophobic content. Well, the post was also shared with an AI-generated image of a mushroom cloud, making the fake claim look very much dramatic and very much believable. And that what makes this so dangerous in geopolitics. A fake military claim, it can move oil prices, it can create market panic, it can influence public opinion, it can pressure governments. Investors may react before journalists finish the checking of the facts. Officials may be forced to respond to a story that should never have existed in the first place. And in the worst case scenario, misinformation, it can contribute to real world escalation. And that is why verification has become part of geopolitical security. Because sharing the next dramatic geopolitical post, ask who is the original source here? Was it independently verified? Is there any official confirmation? And is there any evidence beyond the screenshots and the repost? Because, ladies and gentlemen, in 2026, the most dangerous weapon, it may not always be a missile. Sometimes it is the lie that is traveling at the speed of an internet. And yes, for Indians looking for another migration option, there is one more country that is worth watching very closely. For years, people looked at Canadian immigration and asked just one question. What is the CRP cutoff? But category-based law, that is changing very fast. Now, the better question may be, does any profession it match what Canada actually needs? And that is why specialized category matters here. A transport sector professional with the right experience may qualify under a targeted draw, even when a general express entry candidate with the same overall score, it might struggle. And this is a huge difference. For Indian engineers and tech professionals, this means occupation code. It matters. Your job title alone, it is not enough. Your actual duties, that matters. Your work experience matter, your language score, that matters as well. And yes, your education, most importantly, that matters. A candidate sitting in the mid 400s may look very weak when it is compared with the general draw above 500. But category-based selection may change the calculation completely. Suddenly, the question is no longer, can I beat anyone or everyone? It is becoming, do I fit the specific labor shortage Canada is trying to solve now? And yes, that is a completely different immigration strategy here. Instead of competing against the entire express entry tool, you are looking for the area where your professional background is specifically valued. For a technical worker, that can make a major difference here. The candidate needs to look far beyond the headline, CRS score, and examine the occupation, the NOC classification, in fact, the required experience and the actual job duties. So, if your score is somewhere in 400s, don't automatically assume that Canada is close to you. Maybe you're simply looking at the wrong door here. The Canadian system is increasingly trying to match immigration with labor shortage, and that means skilled migrants need to stop looking only at the highest CRS number. Well, look at the category, look at the occupation, look at the demand, because sometimes the smartest immigration strategy, it is not competing with everyone. Well, the smartest is it is finding the category where you belong. And yes, while Canada is becoming more selective about who enters, India is making it easier for many foreign visitors to enter through more points now. For the diaspora traveling to India, it is not always a holiday. It can mean maybe visiting parents, attending a wedding, managing property, meeting clients, going for a pilgrimage, or simply coming home. And that is why India is expanding e-visa network. It matters. The addition of more designated airports and land entry points, it can make travel maybe easier for eligible foreign passport holders. Instead of always flying through the biggest metropolitan airports, some travelers can use regional entry points that may be much closer to their final destination. Well, for someone traveling towards Andhra Pradesh, direct access through Tirupati, it can make a huge difference. For travelers heading into central India, Bhopal creates another possible gateway now. And it's a big change. And yes, the land port expansion is significant for another reason. It shows that India is not only digitalizing the visa itself, it is expanding the physical network through which that digital visa can actually be used. And that matters for second-generation members of the Indian diaspora, foreign spouses, naturalized citizens, and other eligible foreign passport holders who may not have an OCI card, but they still travel frequently to India. But there is one rule that cannot be ignored. An e-visa does not mean every border crossing is open to you. No, you still have to enter through a designated e-visa port. So before you book that connecting flight or that road journey, check the official list very, very carefully, because digital immigration can make travel easier, but the border, it still has some rules. And yes, finally we head back to Canada, where the immigration story, it is moving in the opposite direction. For years, Canada was sold as one of the biggest and greatest nation for immigrants. Students come, workers come, families come, but now Canada is under immense pressure over housing, healthcare, infrastructure, and temporary resident number. And yes, government is responding with tighter enforcement now. Ladies and gentlemen, for Indians, that matters a lot. People with rejected asylum claims, expired permits, serious status violation, or alleged document fraud, they can all face removal action depending on their circumstances. And here is something even migrants need to understand. Not every removal order means the same thing. A departure order is different from an exclusion order. An exclusion order is different from a deportation order, and ignoring an official notice, it can make a bad situation even worse. And that is why people in Canada, they need to know exactly what their status is and exactly when it expires. Don't rely only on a consultant. Don't rely only on a friend. Don't assume that because somebody else stayed after their permit expired, you can do the same thing. Well, if you receive an official letter from CBSA or another immigration authority, do not ignore it. Read it, understand the deadline, get qualified advice wherever it is necessary. And yes, there is also financial side to the story. Families may have already spent large sum on tuition, rent, immigration application, and living expenses. A sudden loss of status, it can therefore become not just a legal problem but a financial one as well. So the safest approach, it is simple. Know your status before there is a problem, because let's be honest, the biggest problem is waiting until and unless enforcement begins before taking your status very, very seriously. The Canadian dream, it is still possible, but the rules around it, they are becoming much stricter. And with that, we come to an end of tonight's Skyline, ladies and gentlemen. These are all 13 stories, and if you look at them individually, they may seem unrelated, but together they tell you a separate story. Indians all around the globe, they are diversifying. They are going to America, they are going to Canada, the UK, but they need to follow every single rule and regulation to maintain the image of Indian diaspora abroad. Well, I'm Driti Atri. This was Skyline, and I'll see you in the next episode.